Hi, my name is Derek Fahey. I'm a registered patent attorney and trademark attorney with the Plus IP firm, and this is going to be a brief video about answers to frequently asked questions that we get about patents and patent law as patent attorneys. So first off, we get these questions a lot. So we know that a lot of people want to know the answer to the questions that I'm going to talk about today. So first off, when we talk about the USPTO, just know that's an acronym for the United States Patent and Trademark Office. So if you hear that term or that acronym, that's what I'm talking about. Let's jump right in. First, what is a patent? Well, a patent is a legal document that allows the person that owns the rights to the patent to exclude others from making, using, or selling or importing a product that's covered by that patent. So it provides a huge competitive advantage many times. And why is that? Well, if you have a patent that covers a product, say for instance you're covering a product that you're selling that's a cosmetic or some sort of software that you own, if your patent covers that software and somebody else actually uses that software without your permission, then you actually would have the right to get them to make them stop doing that and also get money damages if they do. So it's a huge competitive advantage. It also helps ward off competitors from actually breaking into the space. All right, that's the first question we get a lot. The second question that we get a lot is, what is the first to file system? Well, the first to file system is what the entire world operates under. It's the concept of the first person to file a patent application for the rights in a particular invention, if they get a patent, would actually have the rights to that invention. What do I mean by that? Well, let's say for example, someone in Texas invents a particular invention, and then someone in Utah invents a particular invention, the same invention, very close to the time. It's whoever files the patent application on the invention first, the first person to file will get the rights to an invention or that invention. The next question we get a lot is, hey, does a poor man's patent actually work? The answer is no, a poor man's patent does not work. What a poor man's patent is the concept of taking your invention, writing it down on a piece of paper, putting it in an envelope, sealing the envelope, and then mailing it to yourself through the US mail, and then holding on to that document, that mail that shows the date that it was mailed, and so you can prove that you invented the invention at a certain period of time. That does not work. Why? Because even if you invented something before someone filed it, because you didn't file it in the first to file system, you wouldn't own the rights to it. So a poor man's patent is not gonna work. So just know that. The next question we get is, what is a provisional patent? Well, first off, there's actually no such thing as a provisional patent. It's only a provisional patent application. So the provisional patent is filed with the government and describes the invention about how to make it and actually use it. The provisional patent application lasts for 1 year, and then within that 1 year, you must file a non-provisional application for you to actually have patent rights mature into a patent. If you don't file the non-provisional within the year, then you won't get a patent. The benefits of the provisional are that you can actually add content when you file your non-provisional application in the future that you may not know about when you file your provisional. It kind of happens like this. You have a great idea, you file a provisional application with the idea, describing how the invention actually is made and used. And then through the development process, you learn that you have additional features or different additional elements that are really critical to the invention. You can add that within the 1 year when you file the non-provisional application in the future. It's really beneficial for people that are developing products. An invention, it also is much less costly than a typical non-provisional. Why? Because the fees are much less. Also, the attorney time to draft is typically much less when you file a provisional versus a non-provisional. Another question we get is, what can I patent? Well, legally speaking, you can patent any process, manufacturer, machine, composition of nature, or improvement of that. Essentially, you can patent a lot of different things. You can patent an article, you can patent software, you can patent different processes. You can really patent anything that's useful or new improvement, but there are many requirements. You should talk to your attorney about that, but definitely software can be patented, compositions can be patented, certain processes can be patented. So you can patent a wide variety of things. How long does a patent last? Well, a patent only lasts a period of time. And the reason why that is the whole concept behind patent law is that once you file your patent application and it becomes public knowledge, then the entire world benefits off of your new great invention, but you have a monopoly for only a limited period of time. A utility patent lasts 20 years. On the other hand, a design patent in the United States lasts 15 years. So now you're thinking, what is a utility patent? A utility patent protects the functional features of an invention, how software works, the steps of a software, a certain composition, how a particular mechanical device works. The functional features of that device is protected with utility patents. A design patent protects the ornamental features of an article. So for example, the look of a statue, a look of a book bag, a look of a perfume bottle. Those are all things that can be protected with design patents. And lastly, how much does a patent application cost? Well, depends on the type of patent application you're filing. For example, if it's a utility or a design patent application, there can be different costs. Utility patent applications are generally more costly, and amongst those, you're going to pay different costs depending on the type of invention it is. For example, if it's a software-related invention, it typically it's a higher cost. If it's a mechanical invention, it'll be below that, and then a simple mechanical invention will be even below that. Generally speaking, for simple mechanical type inventions, you're probably looking to spend between $5,000 and $7,000 or so. For average complexity, you probably would spend between $7,000 to $9,000. For software and electrical type inventions, you probably would spend on the higher end, so between $8,000 and $10,000 typically is how much it costs to prepare and file a patent application. Why does it cost so much? Well, you have to hire expert attorneys like myself that actually can draft the application, know what they're doing, and it takes many hours to draft a patent application, so that's why the cost is so much. Hopefully that was helpful, and if you have any questions, please send us an email, go to our website. Our website address is www.plusfirm.com. If you have any questions for me or any person in my firm, please give us a call, or we'd love to chat with you and answer more questions about patents. We certainly can help you.